Welcome to this latest installment in our Distinguished Speaker webinar series on the very timely topic of the First Amendment in schools today, divisive concepts, targeted speech, and safe spaces. Our distinguished guest today is Azhar Majeed, a civil liberties attorney who has spent his career defending the free speech rights of university students and professors. A graduate of the University of Michigan Law School, Majeed previously served as Vice President of Policy Reform at the Foundation for Individual Rights in Education, or FIRE, where he worked to improve colleges' policies on free speech and due process, and helped to create a freshman orientation program to teach incoming students about the rights and principles enshrined in the First Amendment. He is currently a contributor to the NYU School of Journalism's First Amendment Watch, where his articles and commentary help to document threats to freedom of expression nationwide. Azhar, thank you so much for being here today.
My pleasure.
And to those who were attempting to watch live, we apologize for some of the technical difficulties, but we are glad we are able to go forward. So first of all, Azhar, let me ask you this. How did you get into this area? I mean, First Amendment, especially in the education area, it's a fairly specific area for someone to devote their entire career to. How did you get into this? Why did you pursue this?
That's a great question. I'm not sure that if I were sitting here, 14 years ago, when I was finishing up law school, I would have necessarily predicted this. I went into law school with civil liberties and First Amendment rights in mind. It's something that I hoped to make a career out of. And by joining FIRE, I was able to specialize in free speech, specifically in the higher education setting, while still paying attention to lots of trends and cases and everything else that goes on in the civil liberties world. But it's a fascinating area of the law. It's as you said, it's timely. Today may be more timely than it ever has been, and it's certainly something that's rewarding and personally gratifying to myself.
Well, I'm glad that you are doing it. I'm glad that you're here. So before we get into some of the more recent developments, and obviously there's a lot to talk about these days, but for those of us who haven't really dealt with the First Amendment much since law school, or maybe for those of us in the audience who haven't gone to law school yet, or haven't gotten to their constitutional law class yet, if you can, it's a tall ask, but provide us a very high-level overview of some key First Amendment concepts. What does it protect? What does it not protect?
Absolutely. I think in the higher education setting, it's important to make clear that the First Amendment is fully binding on public institutions, public colleges and universities, everything from community colleges up to your large state university systems. Conversely, it does not apply to private institutions. They have their own First Amendment rights to associate around shared beliefs, for example, in the case of religious institutions. I will provide a caveat there, which is that in certain states, California being one of them, there are laws such as the Leonard Law, which applies First Amendment standards to private non-sectarian institutions. So in that sense, the First Amendment does apply to certain private institutions. In terms of free speech rights at those schools, by and large, what we typically look for is what those schools provide in their student handbooks, codes of conduct, and similar policy materials, because under a sort of a quasi-contract theory, once a school has set forth certain rights for students, then it is contractually bound to follow those promises. So that's a little bit about how the First Amendment applies to higher education institutions. In terms of what the First Amendment requires, I think the short and quick answer is that it protects the vast majority of speech out there. It's in some ways, it's more instructive to look at what the First Amendment doesn't protect, because they are such narrow and enumerated categories. Things like defamation, obscenity, harassment, true threats. A few exceptions that have been well recognized by courts for years and years, really decades. But short of that, speech that doesn't fall into one of those categories typically is protected by the First Amendment and should be protected at a higher education institution that holds itself out as one that upholds the First Amendment and values free speech.
So I know we're here to talk about the First Amendment in the education context, but I think it's useful to try and ground this more broadly, because I think a lot of people, when I went to law school, may have a fundamental misunderstanding of the scope of the First Amendment. You talked about how it covers public schools, but not private schools, unless a state law, like in California, extends the First Amendment principles to private schools. So, what is the connection with having the government involved? You know, let's say, for example, if I own a private restaurant or bar and someone walks in and I don't like what they're talking about, if I tell them you can't say that, you got to leave, does that violate the First Amendment, or does it purely only apply to public or government functions?
Yeah, no, that's a great question. I think it's probably something that free speech advocates like myself take for granted, but the point should be made clear that public universities really are arms of the state government. They receive funding from the state. In almost every state, the big state university system, as well as other public universities, are considered to be government actors. And that extends to individual administrators, the leaders of that campus, really anyone who has a stake in terms of regulating student rights as well as faculty rights. So that point should certainly be made clear. In terms of the rest of your question, I guess the way I would break it down is that there's what the law requires, and then there's what I would simply call free speech principles that are at play in campus speech debates. And this is more of a normative issue, obviously, and not strictly what the law requires. But again, for a free speech advocate, we're in the practice of making the strongest possible argument for any type of speech protection. And so it's not simply what is the minimum or what is the floor that the law requires, and versus what can a university get away with. What I am interested in always doing is advocating for the strongest possible protections based on what a university really should ideally look like, and what conceptually what free speech in higher education should look like.
But again, so I'm going to circle back to my example, though, right? Because you just want to make sure I understand it. So, in general, am I correct that the First Amendment prohibits government or an arm of the government from censoring individuals? It doesn't necessarily directly apply, and I know you're saying maybe it should, right? But it doesn't necessarily directly apply when it's one private individual attempting to censor the
Correct.
speech of another private individual. Is that right?
Yeah, absolutely.
Okay. The reason I wanted to press that home is not because I'm trying to push back and say, well, it shouldn't be that broad, right? I mean, I think a lot of times, there will be people in a situation and someone will say something that another person doesn't like, and will say, well, it's a free country, I can say what I want, right? And, it's true on one level, right? But, I think the idea that the First Amendment actually is implicated every time one party is pushing back on the speech of another party, I don't think that's necessarily doctrinally correct. Is that fair to say?
Yeah, I share your interpretation of it. I mean, I think that's one of many sort of free speech tropes or misnomers that are out there. I think there are oftentimes popular misconceptions about what the First Amendment does or does not protect, when it does and does not apply. So yes, it is very important to lay that out. Just sort of the lay of the land of what the law spells out.
Now, another core principle in the First Amendment context is content neutrality. Can you talk a little bit about what that is and how that applies?
Absolutely. I mean, it really is what it sounds like, that generally government regulations on speech should be content and viewpoint neutral. In the higher education setting, there are situations in which you can make some content-based or viewpoint-based limitations, but by and large, what the First Amendment does require is content neutrality and viewpoint neutrality. I'll use the example of funding for student groups and organizations on campus, because that comes up quite a bit.
Right.
And this comes up whether it's the university that's doling out student fee funding, or whether it's the student government or some other campus body. But generally, what the First Amendment will require in that setting is that those funding decisions be made irrespective of a student group's viewpoints, what type of activities or what ideologies it believes in. On the other hand, if you can make viewpoint neutral funding decisions, such as those based on what allocations are necessary for certain types of events on campus, or what the size of the group is, those kinds of things, that gets to be viewpoint neutral. So that's an example in which those principles frequently come up on campus.
Right. So I guess to illustrate that, so a public university couldn't say, well, we're willing to fund conservative student groups, but not liberal ones, or vice versa, right? They couldn't do that. But if a conservative group says, well, we want to have a protest where we march around the university president's office 50 times, right? They don't care that what they're espousing is conservative. It's that a student group isn't allowed to just go march around the president's office and interrupt a meeting. Is that sort of a fair example?
Yeah, that's a fair example. I mean, the type of cases that I personally have come across, it's usually not as cut and dry or as obvious as this is conservative versus liberal, but to use sort of a subset of that, something that comes up on many campuses is, well, we already have a student group that represents this viewpoint, so we don't particularly feel like we need to fund your organization. That is a viewpoint-based decision, because what you're saying is that we don't want to introduce your viewpoint or your ideology to the marketplace of ideas, and we determined that to be unnecessary on this campus. Again, that's based on and looking into that group's viewpoint. It's not a viewpoint neutral decision.
Right, makes sense. Now, we've been talking so far about in the higher education context, and obviously there's a lot of issues that arise there, but the First Amendment applies in the K through 12 context as well, right?
Absolutely.
So what principles that would apply to the higher education context also apply in the K through 12 context, and to what extent do the principles differ in those different realms?
Well, I would say that First Amendment principles, First Amendment rights should apply more strongly in the higher education setting, simply because you are talking about, almost exclusively folks who are 18 years of age and above. Legally speaking, they're adults. On the other hand, in the K through 12 setting, obviously, you're still talking about school children. That being said, decades of Supreme Court precedent, as well as lower court decisions, do make clear that K through 12 school children retain most of their free speech rights in the school setting. So again, whether it's social media, whether it's regulation of a school newspaper, or simply what one student says to another, by and large, the First Amendment requires protection of most such speech. And again, a touchstone inquiry is whether a school regulation is content and viewpoint neutral.
So you mentioned Supreme Court precedent. Let's talk a little bit about that. What are some of the key Supreme Court precedents that have established the governing principles for the application of the First Amendment in the school or higher education context?
Well, your question is certainly timely, because just last week, we had the Supreme Court decision in the Mahanoy School District case out of Pennsylvania, and we can certainly talk about that. But historically, you go back to 1969, the Tinker v. Des Moines Area School District case. It's sort of in a non-legal sense, it's often referred to as the armband protest case, because it involved two school children who protested the Vietnam War by wearing black armbands to school. I believe they were middle school students, in fact, so this is not even at the high school setting. But this case went all the way to the Supreme Court, and what it really established is that school regulations on student speech, the standard that the case requires is material and substantial disruption. What the court was looking for in that case was the students wearing these armbands, did they in some way, in an appreciable way, materially and substantially disrupt the educational setting at that school? And the court determined that they did not, and therefore the students' free speech rights were vindicated. So really, you go back to Tinker, and in many ways, even though it's going all the way back to 1969, to a very different time and place, it really is a cornerstone in this area. Doctrinally, it certainly sets that precedent that so many other cases have followed since then.
Although in a sense, not that different at all. I mean, the Tinker case was over 50 years ago, but I mean, I remember hearing in the news about situations where, a student or a teacher might wear, say, a Black Lives Matter t-shirt to school and,
Right.
Got reprimanded for that. So it's actually kind of similar issues in a way, right?
Yeah, it is. Factually speaking, it is, simply because I think, there's still so much power in symbolic speech, symbolic protest, silent protest, all these sorts of things. So whether it's an article of clothing or some other form of peaceful protest, that's never, in my opinion, that's never going to not be timely. So it is important that we still have that case and that precedent before us.
Now, what are some other key Supreme Court opinions between 52 years ago and last Thursday that have sort of laid the groundwork for free speech principles in education?
Yeah, there are a number. I guess I would highlight two in particular. One is Hazelwood v. Kohlmeyer from 1988. This one had to do with, I mentioned student newspapers a few minutes ago because freedom of the student press is such an important issue. And in that case, the court actually upheld a school district's restriction and regulation of a school-sponsored paper. I believe it was from a journalism class. And the standard that they looked for there was whether the school's regulation met legitimate pedagogical interests. And that's a pretty low bar in some ways because it gives a lot of discretion to the school as well as to individual administrators and principals and teachers. But really, that is an important precedent and one that has had a lot of ripple effects over the years. I myself, as a free speech advocate, find some holes in that opinion and in the legal reasoning involved there. But it is one that you have to recognize as central to this field, certainly when you're talking about student press and related issues. And so that standard of legitimate pedagogical interests, does endure. The other case I'll highlight here is one that many people might have heard of because it is from not that long ago, and that's the 2007 Supreme Court decision, Morse v. Frederick, which had to do. This is the case that made the phrase "bong hits for Jesus" famous in legal and non-legal circles, but it had to do with a student banner at a school-sponsored event. Although the characterization of that is somewhat, murky because I believe there was an Olympic torch relay going on in front of the school, if I remember right, and some students had unfurled a banner that said "Bong hits for Jesus." Ultimately, this going before the Supreme Court, the court did uphold the school's punishment of that speech, but did so on somewhat narrow grounds, saying that the school is justified in taking action against, advocating for illegal drug use. So it sets sort of a narrow precedent in that sense, but it is one, it is a very recent, not very recent, but one of the more recent student speech cases to come from the Supreme Court. So it's notable for that reason. And so, yeah, I wanted to highlight that one as well.
So basically, and I think that's what you're referring to, right? So kind of it's the exceptions that help define the contours of the rule, right? We have precedents that say that schools can regulate speech if it has a material and substantial disruption, right, of school activities, if there's a school-sponsored activity or event or publication, and there's a legitimate pedagogical concern, or if advocating illegal drug use. Ironic now that, at least in certain places, marijuana is not even illegal anymore, but so certain sort of carve outs from this general principle that student speech is protected. Is that a fair way to characterize it?
I do think it is. I think it's in some ways it's sort of like the exception proving the rule. I think that you learn a lot from the narrow exceptions, which is that broadly speaking, there are all these protections in place, and for good reason, both legally and normatively. Again, I would say that these principles that undergird the K through 12 setting should only be amplified in the higher education setting because you're talking about adults, legally speaking.
Right. So now we get to today or Thursday, right? We have the Mahoney opinion. I'm not sure how to pronounce it best exactly. I've seen different ways. But basically Mahoney School District versus BL. So what was at issue in this case and what did the court decide?
It's a fascinating case in some ways. I think I read an article, was it on Slate, that said that the future of student speech rights comes down to a foul-mouthed cheerleader, something like that, because, really those were the stakes in this case. And so essentially you had I think the student was a 14-year-old minor who did not make the varsity cheerleading squad at her school. And so she was upset. She posted something on Snapchat. And it's important to set right off the bat that this was off school grounds, not during a school day. I think it was on a Saturday afternoon. I was not using school devices or internet or anything like that. Purely private off-campus speech. And so, she left a profane message expressing her displeasure with the cheerleading squad as well as with the school and pretty much everything in the universe, seemingly. But the crux of the school district's argument was that this had an impact on the learning environment and on the school because people came across it on social media and because it had that, simply, it was sort of a circular argument that because people were aware of it, it therefore had an impact on learning. And so that's the factual background there. Ultimately, the ACLU sued on behalf of the student. I think this was back in 2017. And the Third Circuit ruled in favor of the student last year, and then it went before the Supreme Court shortly thereafter.
And so what did the Supreme Court decide?
Yeah, so happy to say, this is one that is the decision that a lot of us were waiting for, and happy to say that the Supreme Court decided in favor of the student. The majority opinion was written by Justice Stephen Breyer, holding that the school did in fact violate the student's rights by punishing her. And they did use, I guess I should backtrack a second to the Third Circuit's decision, because that one pretty broadly ruled that the Tinker test of material and a substantial disruption does not apply to off-campus expression, such as this social media post. So this was a pretty far-reaching opinion in the sense that this landmark case from 1969 and this very important legal test simply does not apply to off-campus expression. It's a very speech-friendly, speech-protective ruling. The Supreme Court decision disagreed on that point, and so it sort of narrows the protections in that sense. Still holding for the student, still holding that this was protected speech and that the school was not in the right in protecting her. But the court did make clear, or the majority opinion, I should say, did hold that Tinker does still have some relevance to off-campus speech, such as the one at issue in this case. And specifically, it lays out certain scenarios where even when speech takes place off campus, it could potentially have a cognizable impact in the school environment. I think they specified things like allegations of bullying or harassment that targeted particular individuals, as well as true threats. Again, there's that true threats exception to the First Amendment. When you have threats aimed at teachers or other students, the court held that does have that the Tinker test does have some relevance when you're talking about those things. So I guess you could say it wasn't quite the blank check that the Third Circuit ruling was. It didn't go quite as far, but still very, very important ruling. I can't underscore enough how crucial of a win this is for student free speech rights.
And you mentioned the majority opinion. So, I mean, really was sort of an alignment of what people would think of as traditionally conservative and liberal justices coming out for the majority here. What about the dissent?
Yeah, so that is something that's interesting to me. If I remember right, it was an 8-1 decision, and you had Justice Thomas as the lone dissenter. I found his, frankly speaking, I found his opinion somewhat confusing. I think frankly, I may simply have to reread it in some ways, but it seemed to really emphasize the extent to which social media posts, speech taking place on social media, can infiltrate the educational environment. In my opinion, it sort of overstates how much of an impact that can have. So I think it may simply be, we talk sometimes about how facts and technology, that the law struggles to catch up with the facts on the ground and with technological advances. This may simply be one of those, because it's important to point out that the speech at issue in this case did not identify any particular individuals at the school, did not target anyone, whether they be a student or a teacher or the coach of the cheerleading squad. It was simply a rant that was personal in nature. So it's difficult for me, just as a factual matter, to accept the dissent's conceptualization that this could really and meaningfully infiltrate the educational environment, such that you could characterize it as a disruption.
Now, I know you said that the majority opinion, was sort of considered a win for free speech advocates. But given that the Supreme Court didn't go so far as the Third Circuit and basically saying Tinker doesn't apply off speech, does it create a problem going forward that the Supreme Court declined to set down bright line rules about when it does and doesn't apply off campus?
I do think so, potentially, yes. Especially, well, I wouldn't say, I would say for both the courts and for students and parents and other interested parties. For the courts, I think, again, this is we see this sometimes in free speech law where a Supreme Court decision doesn't leave all the questions answered, and then it really is up to lower, federal district courts as well as appellate courts to sort of fill in the gaps. And I do think this will be a situation where that is the case. For parents, students, teachers, I think you are left with less than clear set of guidelines in terms of what do students' speech rights from 2021 onward, what do they look like, particularly on social media. So yes, I do think it leaves some questions unanswered.
Although perhaps, maybe it's not as uncertain as it may seem, right? Thinking with my law professor hat on, right? So if we think of like different hypothetical scenarios, different permutations on the facts in the Honig case to see how that might play out, I would assume that, if the kids are in class on their laptops and they're messaging each other via Facebook Messenger, something like that, that probably would be considered, if it was disruptive, right? If other students were noticing, or if it was harassing and promoting drug use, right? I mean, that would be no different than if the students handed a physical note to each other. That probably the school would have a right to regulate that speech. Does that sound right to you?
That does sound right, and I think you're right. You can play with all sorts of different permutations if you change one fact here or there. Certainly, I think the classroom example may be a clearer one because it's an analogous situation to passing out notes or preventing somebody from paying attention in the classroom. But let's say you have somebody who, depending on what the social media platform is that they use, let's say they do tag or name specific people at the school in what they are posting.
Right.
But it still takes place outside of school hours, outside of the building, not using any kind of school network or resources. Does that meaningfully change the factual pattern such that you have a different outcome legally speaking? I'm not sure. I think just given the way in which the majority opinion heavily emphasizes the factual scenario in this case, I do wonder about that, and so I think that's something that we'll have to wait and see for future cases.
Right, and you mentioned school network of resources. I mean, it would seem to me, that if they were on a school platform, and obviously, virtually every school in the country was forced to shift to remote learning with the pandemic last year, right? So understandable why we could say, well, you can't necessarily make this clean, bright line on campus, off campus distinction anymore, given the prevalence of online learning. But again, it would seem to me that if a student posted something offensive or disruptive, or whatever, on a school classroom network, right, on a discussion board or something like that, again, that would also be a relatively easy case, because it would seem to me to be a straightforward application of the principles that were already laid down prior to the Honig case in terms of material and substantial disruption, or things, or legitimate pedagogical interest, school sponsored speech, things like that. So maybe it's not as hard as it seems. There's always going to be cases on the margins, but maybe it actually will end up being sort of straightforward.
Perhaps, although to be frank, I probably have my doubts just on some of those things. Just I think the remote learning aspect that you mentioned is kind of an interesting one here, and it's one that merges together the school environment and people's private lives. So, I know that in the higher education setting, we saw a number of cases and controversies over the past year that had to do with so-called Zoom bombing. I think that's in many ways, you can draw an analogy between that kind of conduct and a physical disruption of the classroom setting, such that it's a straightforward deal in terms of regulating that. But then what about things like people who have backgrounds on their Zoom, whether it be a flag or whether it be something that somebody else finds offensive? You could say that, well, that falls under that same kind of disruption of the learning environment. On the other hand, that student could reasonably argue that that's my home or my bedroom or whatever, and you don't have a right to regulate what I put up on my walls or whatever the case might be. So there is some of that blending together, and I think again, as we move forward, if online learning in many ways is here to stay, then it will continue to introduce some of those harder questions.
Now, we actually have a question from the audience, and I may try and weave some of these in or save some time at the end, depending on how things go. But interesting question, right? Because we've talked about, schools having a right to try and prohibit speech that promotes illegal drug use. We've talked about, obviously, court mentioned harassment, right? Even if it occurs online, bullying, things like that. So the question is, it's the interaction between societal norms and doctrine. We're going to get to legal versus non-legal issues a little later too, but I think it's interesting because I think the definition, to paraphrase the question, of what's considered harmful speech has changed, right? Not only things that would be, have considered, traditional bullying 30 years ago, right? Threatened to beat up a weaker student or something like that, but insulting or offending someone based on, gender, sexuality, ethnicity, right? More sensitivity to microaggressions and things like that. So I guess the question is, as the conception of what constitutes harmful speech seems to broaden, will that mean that schools will be able to use that to justify regulation of a broader and broader category of speech? I don't know if you have thoughts on that.
Yeah, I mean, I guess the quick answer to that is I hope not. I hope to see other responses, better responses. I think a lot of what schools, and I'm speaking about both K through 12 and university setting, a lot of what schools can do for students is to help them use their own voice, to use counter speech and responses to that kind of speech, as opposed to the immediate reaction being, well, let's censor that speech or let's take action against that speaker. I hope that's the vein in which we go with many of these issues. To answer your question in a more immediate fashion, though, I do think that that we will see those kind of issues continue to emerge. I think at this point, the idea of so-called hate speech is so ingrained in the public commentary on these issues that it's, I find myself reminding students and administrators 1,000 times that hate speech is not a legal category. It's not something that's an exception to the First Amendment. And yet, if you read really any kind of commentary about these kind of issues, you'll see hate speech used as a as part of the argument or the rationale for shutting down speech. So I think you will continue to see that. I think similarly with microaggressions, different categories of speech that, legally speaking, don't have a legal standard to base it on. It's more sort of a normative or kind of a public commentary type of discourse. But yeah, I don't think those issues are going away anytime soon. And I think it's important for free speech advocates and for the courts to continue to rely on established First Amendment principles to make clear what is and is not protected speech.
We have another audience question, which I think is worth raising now. They ask about off-campus collegiate sporting events, whether sanctioned by the university or NCAA generally. Does this opinion have an impact on those, or would those already be sort of covered as, quote unquote, on-campus school-sanctioned events?
That's an interesting question. I don't think this opinion, my read of it is that it would not quite reach those types of cases. I think you have to, in many ways put those in the on-campus rubric. And not only that, but you have a particular set of circumstances whereby you don't just have students as private citizens expressing themselves. These are in many ways, student athletes representing the school, wearing the uniform, at school sanctioned athletic events. So, it sort of falls under a different rubric. That being said, and as many free speech advocates have pointed out in the last few years, student athletes don't shed their constitutional rights simply by, getting a scholarship and agreeing to be an athlete at that school. I think it's very important to recognize that they are students first and foremost, and that should still be part of the analysis. So, I guess the way I would say it is, it's not an all or nothing deal, and that they do still retain significant speech rights, whether or not they are athletes. And in many ways, again, this is where I sort of depart from the law and speak more normatively. I do think it's important that when people have a profile or a certain platform to raise awareness, to bring up certain issues, they should be afforded the right to do so. It's really for the betterment of society. and it brings visibility to certain issues that may not get that visibility otherwise. So I do think on the broader topic of student athlete speech rights, I do think it's important to continue protecting those rights for a number of legal as well as policy reasons.
Now, I want to switch gears and talk about a related topic. We've talked about court precedent. I like to talk about legislation. There's been a lot of proposed or actual legislation from a number of different states recently that's addressed towards quote unquote divisive concepts, one of the terms used in the title of this talk. Can you describe sort of what the background of that is and what the controversy is there?
Yeah, happy to. And this is one that's particularly troubling to me because it just has not gone away over the past year. And I guess I'll start with last fall, where the Trump administration issued an executive order. I believe it was in September, and had to do with what they called combating race and sex stereotyping. And so this executive order, what it really was aimed at was banning things in schools like trainings and teachings that, as the executive order put it, perpetuated divisive concepts about race and sex. So things like critical race theory, or discussion of whether or not there's systemic racism in America, and whether society is constructed in ways that are built on structural racism. In my opinion, that these are very very important topics to discuss. I am not a critical race theory expert, but certainly you can see how this falls within the academic freedom and free speech rights of individual professors, and really it's something that should be up to individual schools to determine as far as the curriculum goes. I think it's problematic anytime you have the executive branch or the legislative branch sort of putting its thumb on the scale of what should be taught. Really, that's what was happening here. The executive order was rescinded very quickly by the Biden administration in January of this year. I think almost within a week or so of President Biden taking office. However, what we saw after that was this same approach sort of trickling down to the state level and to state legislatures. And so in a number of states, what you've seen over the past 6 to 8 months is state bills that are aimed at the very same kind of speech and activity, whether it be in the form of teachings or diversity trainings, and other types of protected expressive activity. Again, much of this is couched in terms of, does something like this rise to the level of racial harassment or racial discrimination? But it doesn't take a First Amendment scholar to realize that what's at issue here is clearly protected speech on important issues of race and gender and that sort of thing. So very much protected speech. It's troubling to see legislators continue to take this approach in a number of states, really across the country.
Well, so, I know you're a First Amendment expert, but we've been talking about free speech. I don't know how much you focus on freedom of religion, right? So I don't know if you'll know the answer to this, but, again, I'm not an expert there either. In the freedom of religion context, if I understand, there's this idea that because there's supposed to be separation of church and state, right, that the government isn't supposed to mandate or tip the thumb on the scales of religion versus non-religion or any particular religion, right? And so, and we see cases like this, whether, Pledge of Allegiance and, references to God in schools, things like that. But so I guess the question is, look, if a teacher decides they want to teach critical race theory, right, it certainly seems to me clear that the legislature shouldn't be able to say they can't do it, right? I guess my question is, what about on the other side? What about if, whether it's a school district or a legislature, what if they mandate that a certain controversial topic be taught, right? Does that also violate First Amendment rights? How does it play on the other side of the spectrum? Does my question even make sense in that regard?
Well, I think there's a lot to unpack there, and some of this I do think reasonable minds can disagree, but to me it goes back to anytime you have sort of top-down decision making on what's taught, that's generally troubling to me. It's an attractive argument that well, this is being funded by the legislature, so of course we should have some say in what our schools are being taught. But I think, it's sort of like an inverse pyramid, and as the further you go down into the finer levels of granularity, the more you do that, I think the more those decisions should be in the hands of schools and school boards, and then ultimately teachers and professors. So, I am troubled by that. I think if you want to say that, our state university system should focus on STEM subjects, or should focus on certain humanities but not others. That's one way to do it, and I think there are probably ways you can do it without raising quite the same red flags. But we talked about viewpoint neutrality way back when, and some of this really gets into that level of viewpoint-based restriction. Again, there's the critical race theory element to it. There are some of these state bills that again, it spells this out in the language of the bill, that it's aimed at the 1619 project, which is the New York Times, the 1619 projects. It sort of refocuses the teaching of U.S. history by looking at by viewing it through the lens of systemic racism, going all the way back to slavery and then throughout American history. So in some ways it's a different emphasis or a different way of looking at it from your traditional U.S. history curriculum. And so when you have a state bill that particularly takes aim at those kinds of, at that level of specificity, that's where I see really a problem, where it's hard to get away from the idea that this is aimed at particular viewpoints.
And again, I mean, this isn't a new issue, right? I mean, you had the issue of teaching evolution in schools, right? Which the Scopes monkey trial, Inherit the Wind, right? That whole thing. But I think perhaps part of the issue is that so much of life has become politicized, right, in America today. Obviously, it's not controversial whether you teach. Well, it's not obvious. I was going to say it's not controversial how you teach math, right? But then there was the whole the core curriculum under President Obama, right, about how you teach math, and that was controversial, right? So maybe nothing's not controversial anymore. But I mean, the thing is, as soon as you get into history, right, that is bound up with politics, right? So anytime you're mandating any type of history curriculum, it's going to have political ramifications that one could argue is not viewpoint neutral. Is there any way around that?
Well, not one that's immediately apparent to me. I think you're right that a lot of this is sort of couched in the moment where everything falls along party lines. And perhaps in some ways this was predictable, because you had an executive order from one party that was summarily revoked by a new president coming in from the other party. And then you have this falling along party lines at the state legislative level. So in some ways, I think it is inescapable. That being said, I think the best response, the best we can hope for, is to again argue on principle, on free speech principles, as well as academic freedom principles. I think it's important to not lose sight of that, because it's not just you shouldn't do this because the First Amendment forbids it. It's also this is not the right approach consistent with the academic freedom and best teaching practices of teachers, professors, schools, school districts, colleges, and universities. Again, it's a policy argument, but I think it's one that must be made, and one that people have to understand if we are to get this issue right.
Well, speaking of policy arguments, I want to talk about sort of the difference that we touched on earlier between sort of legal and non-legal, or legal and normative principles, right? So there's been a lot of talk in recent years, right, about schools being safe spaces, right? Talk of trigger warnings, talk outside of the educational context about so-called cancel culture, right? Does the First Amendment have anything to say about any of this, or is this all purely non-legal, non-doctrinal?
I do think there's some First Amendment relevance here, but I do agree with you that a lot of this is sort of definitional in terms of the problems with some of the problems that I've seen in the debates and the conversations around these topics. And I think that has to do with the fact that things like trigger warnings and safe spaces, these are in popular commentary. They're not, legal standards with precise legal definitions. So some of it has to do with that, but I do think there's some First Amendment. The First Amendment can teach us a lot about each of these. I'll use the example of safe spaces, I suppose this goes back a few years now, whereas cancel culture is very much, in the moment. But I've seen and I've heard people conceptualize safe spaces as something like a shield versus a sword, and I can explain that. But that, to me, that helps to conceptualize it. When people use the idea of safe spaces as a shield, that is, they're using their own freedom of association and wanting to associate with with people with like-minded beliefs. The idea is that my student group is a safe space where I would like to have discussions about these issues, but really we want to advocate on behalf of these principles that are foundational to the student organization. I don't necessarily see anything problematic with that, even if they are invoking safe spaces, because what they're really doing is exercising freedom of association, which is a First Amendment protected right. On the other hand, you have the sword, which is sort of using the idea of safe spaces to restrict somebody else's free speech rights. And you often see this, for example, when a student group invites a controversial speaker to that campus, and you have other speakers sort of formed around it saying, well, we should not provide a platform. This campus is a safe space, and we should not allow him or her to come speak here, that they're simply not equipped to do so. And when you do that, then you're using this idea of safe space to cut against somebody else's exercise of free speech rights. So when you do that, that's a little, I guess, more of an aggressive approach, but one that's not consistent with other people's free speech rights. And that's the kind of definitional thing I'm talking about, because people often conflate the two. But depending on how exactly you are exercising the idea of something like a safe space, you may be acting consistent with free speech principles, or you may not be. The important thing to me is that when we are commenting and discussing these issues, we get those definitions right.
So let's talk about that for a moment. So, there have been a number of high-profile instances where, campus speakers were either discouraged from coming to campus at all, or they were shouted down and weren't able to continue with their speech. Do students have a First Amendment right to shout down a speaker, or threaten them into not coming to campus or not speaking? What does the First Amendment say about that?
I think the First Amendment is pretty clear on this. I think it's very clear that protest and demonstrations are protected by the First Amendment, but disrupting somebody else's speech, not allowing an event to go forward, is not protected. Now, that being said, it's often not quite that bright of a line. So you're at a speaker event, you wish to protest him or her. How much can you do within the confines of that event without meaningfully disrupting it, such that it can't go forward? If you are holding up a sign that partially blocks somebody else's view of the stage, is that protest, or is that in some ways disruptive? As a free speech advocate, I'm always going to make the strongest argument in favor of free speech. I'm going to say that that's not, if it's just a fleeting momentary thing, that's not sufficiently disruptive. On the other hand, if you organize some kind of a walkout from that event, does that get closer to the line to a disruption? So, those kind of factual scenarios, depending on how they play out, could get close to that line. But again, in terms of protest and demonstration and handing out literature, things like that, those are clearly, classic instances of First Amendment protected activity.
And looping back to the topic of legislation, there's also been a number of proposed or actual anti-protest laws that have been put forth recently. Is that correct?
That is correct, and that's also something that's not really all that new. I think if you go back 3, 4, 5 years, in response to a lot of those the invited speaker controversies, you had a number of state legislatures producing what were called mandatory minimum sanctions for disruptions of a speaker event. I remember the Wisconsin legislature one was particularly high profile, because it was kind of like a 3 strikes and you're out rule. And the bar for such a disruption was fairly low, where if you have a student protest, it could pretty easily cross the line into what that policy or that legislation deemed to be disruptive. And I think, ultimately, if a student was found to have done that, I think it was twice, they would be suspended, and then on the 3rd time they would be expelled from that university, if I remember correctly. And that's pretty powerful medicine for somebody who's not engaging in any kind of violent or clearly unlawful conduct. So you have those kinds of bills at that time, and that's obviously problematic. And then more recently, over the past year, there have been a number of states. Florida is one of them that in different ways created anti-protest laws. This has to do with protest at large and not just within the campus setting, but certainly has relevance for this type of topic.
So we have another audience question I wanted to ask you because it kind of relates to what we're talking about. So the member asked, does a student have the freedom to promote racism in schools, or is that unprotected speech?
Well, I would say yes. Generally speaking, if by promote racism, you're talking about ideology that may be controversial, but is still something that can be discussed by a student group or by, not a recognized student organization, but sort of an unaffiliated group of students. Yes, I mean, if you want to pass out literature, or if you want to have a meeting about that, or invite a speaker, I think generally speaking, that's First Amendment protected activity. I think where it would cross the line is if you do something like that in a classroom setting such that it intimidates a group of minority students or discourages them from coming to class, prevents them from getting an education, prevents the professor from moving forward with a class discussion, all those kinds of things. That's obviously where you get to the heart of disrupting somebody's ability to obtain an education. But if you're just talking about private discussion of various viewpoints, whether they may be controversial or offensive to some or many people, that's by and large protected activity.
So we've got less than 10 minutes left, and I want to kind of drill down on this a little more because this is interesting to me, and I think this interplay between the legal and the normative. My sense is that whereas maybe 40 years ago, not that I was around, I was alive, but I wasn't talking about free speech back then, but whereas back in the 60s, 70s, right, I think people, at least in the popular conception, would associate standing up for free speech rights with the political left, right? Vietnam protests, things like that, right? Now it seems to me that free speech is under attack from both the political left and right, right? You have the political left saying, it's often, I think, probably more conservative, right-leaning speakers that are being shouted down or being discouraged from coming to college campuses. At the same time, it tends to be more right-leaning legislatures that are trying to put forth divisive concepts legislation against critical race theory, right, or anti-protest laws. It seems to me there's a general societal erosion of respect for or belief in the importance of the First Amendment. So I want to talk about that with the last 2 minutes we have remaining. I mean, I think a common sentiment that would be expressed today, right, to use this example of someone coming to class discussing a racist point of view, right, that even giving voice to that person legitimizes it, and that school shouldn't be in the business of legitimizing viewpoints that are hurtful or offensive or cause such historical harm. What would you say in response to that?
I guess I think there's probably a lot I would say, but if I had to distill it to a few points, I would actually go back to something you said before that, which is, I agree with what you said, because in some ways it sort of feels like we're playing tit for tat with different kinds of speech controversies. It feels like a game of gotcha, just this sort of, well, you censored this speech that I like, so I'm going to do what I can to advocate against this speaker that I disagree with, or whatever the case might be. It just seems like it's sort of a zero-sum game in many ways. So that's hard to repair culturally speaking. I think when you were talking about a hospitable climate for free speech on college campuses by and large, that's going to be a gradual effort and not something that can be fixed overnight. But further education, further awareness about these issues, in my opinion, will go a long way. I think a lot of it has to start at the K through 12 level in terms of people's civic education and understanding of the way these things are supposed to work at a societal level, because I think once students show up on a campus with these misconceptions about free speech, it's a little late in the game to try to change their mind on those issues. So yes, I do think that has to be a lot of it. In terms of how schools and other authority figures can help to rectify the problem, it goes back to the point I made a few moments ago about really teaching students that they have the power of their own voice, and that counter speech and counter protest are a much better vehicle for responding to speech that they don't like, as opposed to simply calling for censorship or defunding or deplatforming. So I would love to see more of that. I think a lot of free speech organizations out there are doing good work in terms of not just standing up for students' speech rights, but trying to work with educational institutions to get some of these questions right. But it really, you really need to have more of that collaborative effort to raise education and awareness before you can sort of fix and address the cultural issues.
So I'm going to play devil's advocate one more time because I think that some would express the view these days that this idea of the marketplace of ideas, right, and the remedy for offensive speech is not less speech, it's more speech, right? Like you were saying, right? Counter protest or counter argument. I think some would say that that whole viewpoint is obsolete, right? That with the prevalence of social media, right, and the ability for people with dangerous or deviant ideas to gain a broad platform has become much broader than it was right before the rise of the internet. The idea that it's very difficult for people to distinguish what's legitimate information from what comes from questionable sources these days, right? That I think some would say, the utility of a broad First Amendment principle, broad First Amendment protection, it's kind of run its course. That it doesn't really have the same applicability today in 2021 that it might have 30, 40, 50 years ago. What would you say to that to wrap up? Why should people still care about the First Amendment and the principles that have underlied it for 200 plus years? Why is it so relevant today?
So it's a great question. It's a complex one. I think there's a short answer and a long answer. I think the short answer for me would simply be it's the best chance that we have in some ways to get these questions right, and that if we don't continue to respect each other's free speech rights, then we're really undercutting the ability of anyone to contribute solutions and to find ways around some of these problems that we've created for ourselves. So I think that's the short answer. It's just that we're kind of giving up on ourselves if we just kind of shut it down and say, well, the First Amendment is obsolete. The longer answer, and I think the more interesting one to consider is, to me at least, and I'm admittedly somewhat of a social media novice, but to me, social media and all these different ways to get your message out really makes students and young people and activists more powerful, more able to get the message out. And I fully acknowledge that none of these platforms are perfect. They're all flawed in their own way, and that there's a lot of noise out there. You sort of have to cut through a lot to get good, to get proper news and information and informed viewpoints and all of those things. But it also gives you an opportunity to get your message out there. And I think that message still holds true today, as it did a few years ago when you had students making the argument that, well, it's not fair to have this highly polarizing person come to my campus because we're giving them a platform. On the other hand, what platform do we have to advocate against racism or discrimination or what have you? That's certainly not a new argument, but students need to be reminded and shown that no, you do have these rights. You do have the power of your own voice, and you have a certain strength in numbers, because you may feel like you are alone or targeted in some way, but in fact there are thousands of other students at just on your campus who feel similarly to the way that you feel. And if you band together, you can certainly raise the profile of your message. And then with the power of social media, it doesn't have to be limited to your campus, and you can join together with activists and other people really across the country, across the world. It's all at your fingertips. And so that would be my message, in terms of responding to those things. I don't think it's do less. I think it should be do more.
Well, that's a great point, and that's a great way to conclude. We are just about out of time. So I want to thank you once again for taking the time to speak with me today. I found it very enlightening, and I'm sure our audience has as well. I want to thank those of you who've tuned in to watch us live. And if you're watching from the archive, hope you enjoy as well. So thanks, everybody. And I look forward to talking to you when we have our next distinguished speaker webinar. Take care, everybody.
Thank you very much.
Thanks.